Good afternoon and welcome to the Public Service Commission of South Carolina. It's Wednesday, May the 8th at 3 p.m. We are here today for oral arguments in docket number 2023-381-E. Let's take a roll call of commissioners. With us virtually we have Commissioner Justin Williams. Present in the hearing room we have Vice Chair Powers, Commissioner Caston, Commissioner Carolee Williams, Chair Belser. A note for the record that Commissioner Thomas is on annual leave this week. And I recognize our staff counsel, Mr. Winburn, to read the docket.
Thank you, Madam Chair. Good afternoon, commissioners and parties. We are here today for oral argument in docket number 2023-381E, which is regarding the amended complaint filed by Unifrax LLC, subsidiary of Lauscha Fiber International, alleging a breach of contract and negligent misrepresentation. Today's argument is in response to Dominion Energy of South Carolina's motion to dismiss the amended complaint, and this proceeding has been scheduled for today, May 8th at 3 o'clock. Madam Chair, I believe all parties participating in this matter are available and the docket is in order. Thank you.
Thank you, Mr. Winburn. Let's take appearances from counsel. Who's representing the movement, Dominion Energy South Carolina?
And good afternoon, Chair Belser and members of the commission. I'm Chad Burgess. I'm in-house corporate counsel for Dominion Energy South Carolina. And with me today is Michael Anselmo from the law firm of McGuire Woods, who serves as the company's outside counsel.
Thank you, Mr. Burgess. And who's representing the respondent to the motion, Alkegen Unifrax subsidiary, LLC subsidiary of Lauscha Fiber International?
Good afternoon, Madam Chair. My name is John Malone. I'm with the law firm of Goldberg Segala, and I'm representing the petitioner.
Thank you, Mr. Malone. Welcome to PSC. I don't think you've appeared here before, but welcome.
No, Your Honor. Please be gentle with me. Thank you.
Likewise. And who's here for the Office of Regulatory Staff?
Good afternoon, Chair Belser, members of the Commission. Joshua Austin on behalf of ORS.
Thank you, Mr. Austin. Just for the parties' notification, I know as attorneys we are accustomed to standing. As we have one commissioner virtually, I need for you to be sure to speak at a microphone. We have microphones at either podium. If you want to remain seated, I do allow that, but just make sure you're speaking into a microphone. As the movement will recognize Dominion Energy South Carolina. First of all, I apologize. Are there any preliminary matters that we need to discuss?
No, Your Honor.
Thank you. Mr. Anselmo?
Thank you, Chair Belser, members of the Commission. Good to see everybody this afternoon. We're here today, as Mr. Winburn said, on our motion to dismiss the amended complaint. The gas contract that Alkegen or Lauscha expressly agreed to allowed for Dominion to request credit support or security from Lauscha, and the contract refutes all the allegations to the contrary contained in the amended complaint. You need not look anywhere else other than the allegations of the complaint. That's the end of the inquiry for the Commission, and it requires dismissal of both causes of action, which I'll go through now. The two claims under the gas contract only are breach of contract and negligent misrepresentation. Both fail as a matter of law. The allegations in the complaint, even if true, which we must assume at this stage of litigation, are directly refuted by the plain and unambiguous terms of paragraph 11 of the gas contract between the parties, which I've now put on the Elmo. Let me see if I can make it a little bit bigger. I'll address each of the claims in turn, so let's start with the breach of contract. I think it's important to note that the company has three ways that protect gas customers: through credit reviews and, as needed, requiring credit support or security from the customer. First, if the company has a contract with the company, they can use the terms of that contract or the general terms and conditions that are applicable to all gas customers, or Commission regulation under Article 4. Each of these provide independent basis. Lauscha has claimed there's no basis in the gas contract that allows for credit support or security. That's paragraph 20 of the amended complaint. That's simply refuted by paragraph 11 of the complaint, of the contract. Specifically what that says, and Lauscha admits in paragraph 9 of the amended complaint that this paragraph controls their term, is a 3-step process. The first is the first thing I have highlighted. The company may conduct periodic reasonable credit reviews. The second is that the buyer, which is the customer, agrees to assist in these reviews by providing financial information. And then the third step, at the request of the company, who is the seller of the gas, will maintain such credit support or security, and then it follows with the menu of options that are available to the customer if a credit support or security is required. So this is plain and unambiguous language which the court can interpret as a matter of law. It is clear that the 3 separate parts allow Dominion to conduct the periodic credit review, which Lauscha's amended complaint admits was done. It requires Lauscha to provide financial information, which, by the way, that is to benefit the customer, because by providing financial information, it verifies the credit review and allows for potential waiver of a credit support or surety. And then the third element is, and in paragraph 11, Lauscha maintains they provided financial information. We might be debating that at a later date, but the fact of the matter is, for purposes of today, they provided financial information. And then the last one is Dominion required Lauscha to maintain the surety. These are all allegations in the complaint. Now, as you can see, because the contract allows Dominion to do the review, request the documents, and require a deposit, that's the end of the inquiry. The claim fails as a matter of law under the contract. Now, I would note that in opposing our motion, Lauscha also claimed that the gas contract doesn't have any method for Dominion to calculate the amount of the credit support or surety. The contract leaves it to the discretion, obviously, of the company to impose that amount. And what do? Rather than just sort of blindly come up with a number, we use a very transparent methodology that is contained in the general gas terms and conditions applicable to all customers, including Lauscha, that has a formula for computing this. And that is the amount equal to the total actual bills of the highest 2 months over a rolling 12-month calendar, right? Now, Lauscha has said there are some qualifications to that, therefore it doesn't apply, the formula. That's just wrong. The company did not impose the deposit under the gas terms and conditions. We imposed it under the contract. And by doing it under the contract, we merely, for transparency's sake for our customers, so they know what they can expect, employ the same formula. That doesn't render it inapplicable because we're operating under the contract, which had no such limitations.
Mr. Anselmo, may I ask a question?
Certainly, please.
With regard to the general terms and conditions that you referenced for determining the amount of a deposit, is that not the same language that is contained in the Commission's regulations?
It is.
Okay, thank you.
It's also contained, yes, you're right. So in sum on the breach of contract claim, it's a simple determination for the Commission. You look at the contract, did Dominion do the 3 things that were alleged in the contract under paragraph 11? Yes, as admitted in the complaint. That's it. That's the end of the inquiry. The negligent misrepresentation claim fails for multiple reasons. I'll go through those. The first claim that Lauscha makes in the complaint is that the gas contract has no provision on the surety amount. Again, we just talked about that. Not accurate. The contract discusses surety and the amount that will be, how it can be imposed. And then again, we use the formula that's applicable to all customers. The contract doesn't limit what Dominion can do in that regard, so an argument that there's no amount that can be calculated because the contract doesn't spell it out is simply incorrect. Then also the relief sought, even if you can get past that first hurdle, Lauscha asks for 2 things in the negligent misrepresentation claim. First, in paragraph 36, I'll address that first, Lauscha seeks relief on this claim. Negligent misrepresentation is a tort cause of action, but they are seeking remedies based on contractual issues. That's simply not allowed in South Carolina. It's the economic loss rule. Kennedy versus Charleston Lumber is a great example. So that makes the claim fail. And even if we get past that hurdle, the relief they seek, one of which is monetary damages, As we all know, this commission has no jurisdiction to award monetary damages. There is a possibility that the breach of contract claim also contains a request for monetary damages. Likewise, can't get it under breach of contract for the same reason you lack the jurisdiction to enter it. But the simple fact of the matter is paragraph 11 of the contract authorized Dominion to conduct the review. The complaint admits that review was conducted. Lauscha maintains they provided the financial information. And then at step 3, the company decided a credit support or security was required. The claim fails as a matter of law because they're directly refuted by the terms of the contract. Happy to answer any questions.
Madam Chair,
Vice Chair Powers?
thank you. Mr. Anselmo, in paragraph 11 is the thing that I find a little bit confusing, which says will maintain such credit support or surety at the request of the company. If it said credit support and surety at the request of the company, it'd be very clear. My concern is the choice of whether it's credit support or surety, is that the company's choice or is it Lauscha's choice?
So the decision to request the deposit is the company's choice. The how you satisfy the request is the customer's choice, and they have a menu of options that are under the contract. They don't have to provide cash. It could be a letter of credit from the bank saying they're good for it. They could take a new line of credit. They could get a bond. They could have there's a menu of options that they are not limited because it's included but not limited to.
Okay.
Finding ways to satisfy.
And there's no question they're a solid company. I mean, they're a solid customer.
Without getting outside the bounds of the complaint, that's a little bit difficult to answer, but I will say this. In order to make it through to get a deposit, there is some question, obviously, as to credit worthiness. Otherwise, you would not make it to step 3.
Okay. All right, thank you, sir.
Sure.
Commissioner Caston?
Thank you, Madam Chair. And good afternoon, Mr. Anselmo.
Good to see you.
I guess building on Commissioner's question, that will maintain such credit support or surety, including, will maintain such credit support. What does that mean?
So it means that there has to be some mechanism chosen by the customer, but obviously the company has to agree it's sufficient, that secures the 2 highest total bills in order to protect other customers. So it can be a true add it to our bill and we'll just send you cash. It can be letters of credit. It can be lines of credit. It could be a bond potentially, but it has to be an actual financial instrument that has value that can be enforced in the event of non-payment, so the company can recover the amount from the customer who then doesn't make payment, rather than having it go across the entire other industrial rate class.
And I'll probably ask this question to Mr. Malone also, but I found 2 different general terms and conditions. Which is the right one?
Both. So because they're an industrial customer, there is the contract that this commission actually approves of in the docket in which the contract was provided, which just for the record's sake, 2009-85G, Order 2022-478, the commission approved Lauscha's contract that I have up on the screen, that is on the LMO that pops up periodically. Also, because they're an industrial customer, they have industrial GTs and Cs that have, let's say, terms that are unique to industrials that wouldn't necessarily apply to other customer classes that take gas. And then they have the general terms and conditions for gas that apply to all customer classes. And the documents all reference themselves and incorporate themselves in each other, but they all apply to Lauscha.
Thank you, and
Sure.
apologize for looking over my glasses.
No problem. If I took mine off, I wouldn't be able to read my notes and answer your question.
Then going back to the 60-day bills or whatever, are you referencing that section 4D?
Yes, in the
deposit?
general gas terms and conditions, I believe it is section 4D.
When I read that particular section, and I think it lists 4 different groups that it would be applied to. It mentions a new customer is it Lauscha or Lauscha?
I say Lauscha, probably. Could be wrong. I don't honestly know. I believe it's Lauscha. I think they're a German company.
Thank you. Are they a new customer?
No, but Commissioner, it is important to understand a point that I made earlier, that the company has independent methodologies in which to impose these deposits. If the company had to rely exclusively on the general gas terms and conditions, I would agree with Lauscha that these 4 things would make a difference, right? You'd have to meet one of the 4 tests. You don't have to do that here because we did not, or the company did not require a credit support or security under the gas terms and conditions. We did that under paragraph 11's authority. We merely use what I call the formula for transparency for our customers so they know what to expect.
Were they aware of the formula, or was that clear?
All
Sure.
customers have notice of the terms and conditions, and they're available publicly on the DMS and our website.
Well, I got to admit, it's just not clear to me right now. That doesn't mean it's not clear.
No, I understand. And it's because there's been some confusion in the responses, I think, about Lauscha's misapprehension of exactly what applies. The sole focus is paragraph 11. It gives us not carte blanche, it gives us the authority under permissible limits enunciated in the contract to impose the deposit. The company could have said the deposit was $1 million and not use the formula. But because this comes up quite often in the context of credit reviews, it's easy to have a consistent methodology, which is very publicly accessible and known to our customers.
So does it not have to be reasonable?
There is no allegation in this complaint that any action taken by Dominion was not standard commercial practice.
Well, I mean, going back to, glad you mentioned that, because that's relevant too. What exactly is that?
That is the limitation on our credit reviews. So, for instance, the company could not just willy-nilly decide that you're no longer a good credit review. You don't have good credit worthiness. There has to be defined standards applied to that, reasonable under, say, for instance, publicly accessible credit ratings, things of that nature, something that's known in the community that has a value. And there is, again, no allegation that how the company did its credit rating review exceeded those standards. There's no allegation that our request for financial documents exceeded those standards, and there's no allegation that the amount requested or how we calculated exceeded standard commercial practices.
But you just said the company could have asked for $1 million. Would that have been reasonable or met that standard commercial practice?
So I think at bottom, I think what you're asking, if I'm wrong, please correct me, is when can the commission review the decision on the deposit? And if there's an allegation of not commercially reasonable practices, then I think you can look to see whether the company actually applied commercially reasonable standards. Here, there's no such allegation whatsoever. I don't think nor could there be, considering the admissions in the complaint of the process and the fact that we're using the commission-approved general term and condition formula that has been longstanding in the general terms and conditions and also mirrors the regulations.
Well, you didn't mention, I guess, section 13, general terms and conditions on the contract. But when I read it,
Are you in the industrial or the general?
It's in the contract itself.
In the contract itself.
Yes,
Yeah,
in the
all right.
contract, which I'm actually reading from.
Yep.
I guess what's attached to my amended complaint.
And that's what I have up on the screen. It's the one that was
Yes.
attached to the complaint in February on February 23rd.
When I look at that last sentence in 13, should there be any conflict between any portion of the general terms and conditions to industrial service agreements? In this agreement, the parties agree that the agreement shall prevail. It's a lot of agreements.
There is a lot of agreement there.
How do you interpret that sentence?
So what that means is if there are two terms that cannot be reconciled between the contract and the industrial terms and conditions, then the agreement will control. But if you can reconcile all the provisions at issue, then there is no conflict, and you don't have to eliminate one or have another one control. Here, the terms of creditworthiness are explicitly put forth in paragraph 11. They allow the request. The only reason we go to the GTs and Cs is for the benefit of the customer. It is not in conflict to compute using an accepted formula. It is in tandem with the creditworthiness provision. Again, to benefit the customer so they know what to expect.
And you're looking at that amended complaint. I don't remember where it was. One of the items here. Let me find it. Anyway, Lauscha mentions that they have a $200 million revolving line of credit. Is that applicable? Can that be surety or not?
So usually sophisticated lines of credit like this between sophisticated parties like Lauscha and their lender will have certain covenants in those lines of credit that restrict what it can be used for. It wasn't attached to the complaint. So we don't know what those terms could be, but to answer your question, it could be, but we don't know if it is because the company has not seen the line of credit, nor has the bank provided a line of credit saying, yeah, the $200 million is good for it. So, but even assuming that could be good for it, you still go back to the three-part rule or steps in the credit worthiness. The company conducted a credit review. We asked for financials in order to waive that request. Nevertheless, we requested a credit support or surety from the company, from Lauscha. So even staying within the complaint, you can make a logical conclusion that that was not going to be sufficient to waive the deposit.
Is Dominion treating Lauscha any different than any other industrial customer you have, gas customer?
Separate from need to determine this motion to dismiss, not relevant to that inquiry, but the answer is no.
Has Lauscha made any offer to satisfy Dominion's credit worthiness requirement?
We had productive dialogue with the company prior to filing the complaint, and then we had some robust settlement discussions with the company, with Lauscha as well.
Are those ongoing?
They have ceased.
I think that's all the questions I have, but can't promise it.
No problem.
Thank you.
Commissioners, further questions? Vice Chair
Madam Chair.
Towers?
Were they delinquent at any point
Again, separate from the
in the
need.
payment?
Yeah, so default is not a prerequisite under paragraph 11. There's no requirement you have to be in default in order for credit review. It's periodic. The company can review anybody at over whatever period they determine. But if you'd like to know the answer to that, separate from your need to determine the complaint, there was one instance of delinquency and the company waived the late fee after discussion with Lauscha.
I think there was section 4D. It says if any of the following conditions exist, customer's past payment record demanding shows delinquent payment practice, customer cannot furnish either letter of good credit, acceptable cosigner, customer has no deposit, presently delinquent, and customer service has been terminated. Service has not been terminated.
Service has not been terminated.
Okay.
And Commissioner Powers, if the company had imposed or requested the surety or credit support under this portion of the GTs and Cs, my argument would be different, and we would have the factual information to show how they would fit into one of those four categories. But because the company has pursued under the contractual basis that does not contain any of these four subcategories, it's not necessary for us to do that or for it to factor in the commission's decision.
Where did the number, the 561,000, what, 591,000, I think it was. Sure. Where did that number come from?
So it is based on usage using the formula of the two highest months of usage based on a rolling calendar year. Lauscha is a combined electric and gas customer, so at that time, the formula made the deposit or the requested surety be in that amount. But it fluctuates based on usage.
May I ask a question on that?
Sure.
Isn't it the two highest consecutive months? It's not just the two highest months, right?
Yes, you're right.
Okay.
My apologies for misspeaking.
Thank you.
Yes. But Lauscha's amended complaint only challenges the gas contract and the deposit imposed under that. So I'm actually a little confused as to why the 591 made it in the complaint, because it includes some electric deposit portion that isn't relevant right now.
So that's not a proper number?
That is not the accurate number.
Do you have an accurate number?
For gas alone through.
Just a minute. We're live streaming.
Oh, yeah.
Is that something that needs to be confidential?
We probably should not put that on public.
Can you submit that to the commission later? I mean,
Yes.
I don't know that it needs to be publicly stated.
Yes, absolutely.
I can withdraw that question.
I think I can answer without giving the number. It is significantly less.
Thank you.
Commissioners, anything further? Can we just talk about the documents? I just want to make sure that I'm straight on these, okay? If you don't mind.
Certainly.
And Mr. Malone, I can ask you the same thing when I get to you, but we'll see. All right, so we have a contract, and that's called the Agreement for Transmission Service with Firm Gas Standby. Is that correct?
Correct.
And that's where you're referencing paragraph 11.
That is correct.
Okay. And that agreement was attached to the amended complaint.
Yes, ma'am.
Then I believe that agreement also incorporates by reference the general terms and conditions to industrial service agreements. Is that correct?
That is correct.
And there's that language in the GTC for industrial is how I'll refer to them, is there's language that said the terms and conditions of the industrial service agreements are supplementary to the rules and regulations issued by the Commission and the general terms and conditions for Dominion Energy South Carolina, Inc.
That is correct.
And we'll call those the general terms and conditions.
That's my colloquial reference. Okay. That's correct.
And I believe that in the terms and conditions, general terms and conditions for the industrial service agreements, there is language that to the extent that these terms and conditions, i.e. for the industrial service agreement, conflict with general terms and conditions, the general terms and conditions control.
That is correct.
Okay. Is it Dominion's position that there is no conflict between the two, that there is no conflict between the two different terms and conditions?
Yes.
Okay.
And just to add a point on that, it's because we are using a formula for mere courtesy, right? We don't have to use that formula under the contract in order to compute what the deposit can be. So we could say they're incorporated by reference and incorporated in the contract. It's not necessary under the plain and unambiguous terms of the contract, paragraph 11, that allows the credit support surety, I keep saying security, surety to be imposed. Is a mere courtesy to use the language from the general GTs and Cs.
And I want to go a little bit further, okay? And then under the general terms and conditions for gas customers, any gas customer, not just industrial, but the general terms and conditions, there is language there that these terms and conditions, i.e. the general terms and conditions, may be supplemented by specific for specific customers by contract. Does that
That's
sound
correct.
familiar? Okay. So we kind of have to read all those together.
Well, everybody has knowledge of, we have the contract. You're familiar with the general terms and conditions through previous hearings. You have to read them together. But again, we're not asking the court for any.
I understand that.
Okay. All right.
I understand that. I'm just trying to
You have the chain correct.
laying some groundwork as to the different documents that are being referenced here.
Yes, I agree with how you've categorized them.
Okay. And you've referenced the formula that Dominion has used. And you said it was available publicly on DMS and through the company. Is that correct?
Mhm.
What formula is that?
Sorry, that's what I call the general term and conditions, section 4D, which is the amount equal to the total actual bills of the highest 2 consecutive
Okay.
months.
It's the
based on-
formula that's contained in the commission's regulations as well.
Correct.
Okay, I just wasn't sure. I know there's something separate on the electric side, and I understand that we're just talking about gas here. I just wanted to make sure that we weren't under something like,
We are not using any electric reg,
or
electric
there was some
contract or anything.
matrix or something filed in an electric case having to do with a waiver.
The original complaint had different allegations and warranted a different response, which was mooted by the
Okay.
filing of the amended complaint. So you probably saw some matrix information in that. But again, that was a separate complaint. It's no longer before you.
Okay. And just to be clear, Dominion has not limited any deposit or surety to requiring cash.
Absolutely not.
Okay, thank you. Commissioners, anything further? Thank you, Mr. Anselmo.
Thank you.
Mr. Malone?
Michael, I'm sorry, you want this? I'm just impressed someone knows how to use an Elmo. All right, members of the commission. Again, my name is John Malone. I represent the petitioner in this case, Lauscha Fiber International. There's words like Alkegen and Unifrax, and basically Unifrax has Lauscha Fiber International as a subsidiary, and then Unifrax is a subsidiary of Alkegen. Again, I know we're here to talk about the allegations in the complaint and a motion to dismiss the amended complaint. And the issue in that case is basically a breach of contract. And under South Carolina law, breach of contract claims are very simple. But when there's any ambiguity in a contract, it's construed against the drafter. And in this case, it is clear that the drafter is Dominion. So as the commissioners have focused on in their questioning of Dominion's counsel, we believe there are some clear ambiguities in these contracts, and we don't believe that their motion to dismiss should be allowed at this time. We should be allowed to, present our case in a full hearing, which is scheduled, I believe, it's next month. One of the things that has been a little bit of a struggle for me, not necessarily swimming in this pool all the time, is trying to make sense of. We've got these industrial terms and conditions attached to the attached to the gas contract. And then we have another set of these terms and conditions. But the timing of them is unusual because the terms and conditions that were what I call them late adopters to this gas contract are dated October 2nd of 2023 when they were approved by this commission. And that has the 4D language that we were talking about earlier. The contract itself was executed in May of 2022 with the industrial terms and conditions, and I believe that there is no conflict between all of these, but I believe that the contract language says that they're all going to be incorporated and read together. And if you do that, then you look at 4D, the cash deposit section. And if you look at the cash deposit section, there's no basis to require Lauscha provide a cash deposit. I mean, we can go through them. It's very straightforward. You've got any of the following. Customer's past payment record shows delinquent payment practice. We would dispute that there was a late payment. If there was one, it took place many, many years ago per the documents I've seen. But again, a new customer cannot furnish either a letter of good credit from an acceptable source or an acceptable cosigner. The contract drafted by Dominion clearly distinguishes between customers and new customers. So we would submit to you that Section 2 only applies to new customers, while Lauscha is not. So it's irrelevant whether or not they've asked for one and we couldn't provide it, or whether we think we need to provide one. Our position is we don't need to provide one. They haven't established the contract allows them to do it. Number 3, a customer has no deposit and is presently delinquent in payments. Again, there's no evidence presented to this commission that that is in fact the basis for why they brought the demand for a cash deposit. And 4, customer has had his service terminated for non-payment of fraudulent use. None of those 4 are going to apply to Lauscha in this particular case. What's interesting is the electrical service contract, which one of the members was referencing. It actually has a 5th condition under this section, and it expressly mentions the credit matrix, which is what Dominion used when it came to Lauscha and said, we want you to post a surety. That was the calculation that they say they used back under the general terms in paragraph 11 was this credit matrix. It's not in these terms and conditions. They do have the ability to add it to contracts because they've added it to the electrical services contract, and it applies in those situations, but not here. So we believe that is again, the drafter should have these ambiguities construed against them. If they wanted to use that credit matrix as a basis to claim that we have to post a deposit, all they had to do was add another paragraph that is terms and conditions 4D. Didn't happen. So again, we think it's fairly straightforward that if you look at what Dominion did in this case, is that first they had a contract. They used language from an electrical services contract to somehow trigger some credit review, applied those standards, which are not in this contract, and then when they realized that their original terms and conditions that were attached to our contract back in May of 2022 had no provision for a cash deposit, we get the October 2nd, 2023 amended terms and conditions that are now part of our contract. But even when you look at those, you don't get the answer they want to seek in this case. Again, we've been a good customer for years. If there had been any evidence that we were a non-paying customer or a poor customer, this panel would have heard about it in the answer that was filed by Dominion, because that would have been one of the things they would have looked at. They want to go back to this generic language, which, again, it is pretty generic, but I think that means you have to go look at some of the other details that are more specific. But it says to provide adequate security for protection against the risk of non-payment. That's the language in paragraph 11 that sort of should be guiding their creditworthiness checks. That we don't believe that they can meet that standard, and that's why we believe they are breaching their contract and forcing us to provide any sort of credit or surety given the information that we provided to them. And we believe that it's a fairly straightforward situation that we think the motion to dismiss should be denied, and we should be allowed to have a hearing on fleshing out this issue of whether or not this contract applies the way they say it does and allows them to do what they say it does. And if any of the members of the commission have any questions, I'll be happy to try to answer them.
Thank you, Mr. Malone. Questions for council? Commissioner Caston?
Thank you, Madam Chair. Has Dominion required any kind of deposit or surety previously?
Before the events that lead us here?
Yes.
In all candor, Mr. Commissioner. This discussion has been ongoing with Dominion for a couple of years now, I believe. This same discussion. So it would be, I don't want to speculate and say it didn't happen 20 years ago when it was, you know, it was South Carolina Energy and Gas that was handling this account. So I don't know what happened back then, but I will represent to this commission that these discussions that have been happening between Lauscha and Dominion didn't crop up, you know, last fall. They have been something that has been an ongoing focus of discussion through various, you know, people would come and go within both companies, and so the discussions would get renewed and that sort of thing. But I don't know if that answered your question or not, but that's my understanding of the history of these two parties in this dispute.
You answered the best you could. That's good enough.
That's all I can do.
Did Dominion demand a cash deposit or other form?
Again, if you go back and, you know, look at this case as a whole, like the archaeology of it, you look back at the emails that have been exchanged in the discovery phase of this case, at any point in time, I could say yes, but it seems to be a moving target. Maybe it's part of the negotiation process. I don't know, because I wasn't part of those discussions. I wasn't, you know, involved in them. I'm just telling you what I have personally seen in the discovery that was been provided through Dominion's counsel that suggests that it's been you know, yes, sometimes the number is here, sometimes it's down here, and I don't, you know, again, we haven't gotten into the weeds of that yet because of where we are procedurally in this particular situation. And that's why we think maybe a hearing to flesh out some of those details is appropriate to get to the bottom of this.
Well, since we're here and I've got all this information y'all sent me, I still have a few more questions.
Absolutely. I'll do my best to answer them.
Has Lauscha made an offer of a letter of credit or its equivalent to satisfy Dominion? Do you know?
Your Honor, hopefully that's not the inappropriate term. I don't want to offend you by saying that, but that's what I'm used to.
It doesn't offend me at all.
All I'm missing is the black
Just
robe.
keep it civil and I won't be offended then.
The difficulty in that particular request is this. Lauscha, Alkegen, Unifrax are owned by a private equity firm. And as the commission probably appreciates, private equity, their business model is, you know, they're very focused on income and debt ratios and things of that nature. And voluntarily providing credits, you know, deposits, things like that affects that ratio and affects how they operate their business. So the position of my client is that it's not warranted by the facts in the contract, and therefore they aren't in a position to voluntarily do that because of the nature of the owner of their business and how they operate that business, being a private equity company.
So, if I'm understanding this correctly, Lauscha doesn't believe there should be any kind of deposit or surety or irrevocable line of credit or whatever.
That's correct. We've provided them, as noted in the amended complaint, that we've relayed to them that our owners, the parent company, has a revolving line of credit that was previously mentioned here. It's, you know, that company itself has multiple billions of dollars assets under its control. There's never been a suggestion that the company is not good for its debts. It's got a net 10-day invoicing for this particular account, which, you know, this company, Alkegen, has 57 locations throughout the world. The Somerville location is the only one that they have a net 10 payment or being asked to provide some sort of security for. So if under those facts, my client is concerned about what's being asked of them, we don't see that it's being authorized in the express terms of the contract that we've been provided. And that's where the concern is, that, you know, if there was some legitimate basis for it, if we had, you know, had a history of late payments or there was some sort of actual evidence, that was being requested and they still wanted, to have that service, I would expect the company would honor that request. We just don't think that the evidence there allows it.
Okay. Do you know if Lauscha has any opinion at all of whether a utility has the right or can or should ask for deposits when appropriate?
We don't disagree. Like when we were looking at 4D, the terms and conditions that we were talking about earlier for cash deposit, we don't dispute that there's some sort of public policy argument that Dominion couldn't ask for something allowed by the contract if there is indeed evidence that a condition is met. The problem we see is that none of the conditions have been met.
I asked Mr. Anselmo earlier about the two sets of general terms and conditions, and I think I heard you mention one was provided, I think the gas general terms and conditions or something was provided May 2022, and the other was provided in October 2023. Does the company or do you agree that both general terms and conditions apply to this contract, or is that a dispute?
I don't think that, again, if I understand your question, there was a document, and I believe it's attached to the amended complaint as part of the contract. It's called Dominion Energy South Carolina General Terms and Conditions to Industrial Services Agreement for Gas. And it's a 4-page document. And it's signed by Lauscha Fiber International Corp. And Dominion Energy South Carolina, and it's dated May 31st of 2022. Those terms and conditions, I would submit to the commissioners, have nothing to do with the reason why we're here, because there's nothing in those terms and conditions that talk about creditworthiness or deposits or anything. Those are absolutely silent. So then if you turn to the more recent terms and conditions, which are dated October 2nd of 2023, that's a 12-page document that's called General Terms and Conditions, Gas General Terms and Conditions, I guess. That does contain the 4D section that we've been discussing here this afternoon. And so I do think that, that does apply, but these two documents don't conflict with one another, the two sets of terms and conditions, because the issue we're talking about is only in one and not the other.
So if I'm understanding Lauscha's argument, Lauscha does not agree or believe that the terms in the general terms and conditions in the latter terms and conditions are applicable.
That's correct.
Are you disputing that they should even be included, or?
No, I think that my understanding is that once these terms and conditions were submitted to the commission for approval and they were approved, they become part of the contract as a matter of course. We're not disputing that it's, I think they probably are effective from October 2nd, the date they were approved, and if we were talking about something happened before that, but we're really talking about something that's forward-looking. In this particular case, Dominion wants us to provide some sort of security. So I think that the second set, the October 2nd, 2023, I think would apply to the discussion that we're having here. We just don't believe that the 4 categories that the terms and conditions say must be met, one of them must be met, haven't been met here. And therefore, it shouldn't apply. Yes.
Mr. Malone, would it make any difference if there was a set of general terms and conditions that was in effect at the time that the contract, and I'm talking about the 12-page document, not the 4-page that was attached to just the normal gas general terms and conditions, not the ones that with the industrial. Would it matter if those were in effect before October 2023? To your argument? Because let me tell you, there was a set of gas general terms and conditions that were in effect prior to October 2023. What is attached, I think that you had attached, that was from a commission order, a reference to commission order, they were just updated by that last rate case in that docket 2023-70-G. And I recall one of the amendments was to add DESC, because I think it referred to the company throughout, and they added or DESC. And I think another one had something, it either defined act of God or force majeure, had something to do with it, changing the definition. But there were terms and conditions in effect prior to October 2023. Would that matter?
Since I don't know what those say, I can't. Because again, just to be clear, for the commission's sake, and I know that we're sort of moved far away from a motion to dismiss, but this October 2nd, 2023 document was provided to us by Dominion's counsel during the litigation, or during this dispute.
Well, that's the most recent version.
And the only one that my client had that was signed is the one that we've attached. It has the date of May 31st of 2022. So I'm not here to disagree with what you all had approved and had in place back in May of 22 when this contract was signed. I'm just telling you that wasn't part of information that my client had. But if it has the same language, the four different categories, it doesn't matter whether you looked at it in May of 2022 or October of 2023 or May of 2024. We don't believe that any of those four categories, which are spelled out, have been met.
I understand that.
Okay. I'm sorry.
Yeah, I understand that argument.
Okay.
That's just most of our utilities have, some of them call them service regulations that apply to everybody. Some of them call them general terms and conditions. It just depends on the utility of what they've got. So anyway, that's all I was asking. Would it matter?
Okay.
Thank you.
And thank you, Madam Chair, and thank you, Mr. Malone. I'm sure as soon as you step down, I'll have more questions.
Okay.
And I guess a suggestion that you and Mr. Anselmo just go outside and flip a coin won't work. But that said, thank you so much for being here. I appreciate it.
I appreciate the opportunity. Thank you.
Hey, Madam Chair, this is Commissioner Williams.
Commissioner Justin Williams.
Thank you, Madam Chair. Good afternoon, sir. How are you doing today?
I'm doing fine.
Good. Welcome to the commission for the first time. Hope to have you back again at some point in the future. Could you go down the list of the four requirements that Dominion argues need to exist in order to request credit worthiness, and why you don't think they apply here?
Sure. And to be fair, I want to make sure that as I answer your question, I'm going to do my best to answer your question, that I do want to note that based on Council's presentation today for Dominion, their position today is that 4D doesn't apply to this case. It's only the paragraph 11 creditworthiness in the general contract. So you suggested that that was Dominion's position, and my client's position is that those terms in 4D should apply to this particular situation. That's why they aren't met. So I wanted to preface that as I answer your question to make sure that I wasn't misrepresenting Mr. Anselmo's argument here today about where the commission should be looking. So what we have in 4D is there's four categories, and it says a maximum deposit in an amount equal to an estimated 2 months of a bill for a new customer, or an amount equal to the total actual bills of the highest 2 consecutive months, if any of the following conditions exist. Number one, the customer's past payment record to the company shows delinquent payment practice. And we don't believe that element number one is met under any of the facts of this case. Number 2, a new customer cannot furnish either a letter of good credit or an acceptable source or an acceptable cosigner or guarantor on the company's system to guarantee payment. Number 2 is distinguishable from the other 3 in that it says it's a new customer. And as Dominion conceded here today, Lauscha is not a new customer. So we believe that number 2 as a criteria just isn't applicable to Lauscha under any circumstances. We're not a new customer. Number 3, a customer has no deposit and presently is delinquent in payments. Again, there's no evidence before this commission that we do have no deposit. We haven't had to put a deposit down to this point, but we're not presently delinquent in payments. We would suggest to this commission that there's never been a delinquent payment from Lauscha during the time that we've been involved there, but that's number 3. Number 4, a customer has had his service terminated for non-payment or fraudulent use. Again, there's no evidence that Lauscha falls into category 4 because we've not had the service terminated for non-payment or we've not been accused of fraudulent use. So of those 4 categories, that one of them must be met in order for this subsection D to apply, we don't believe that any of those have been met by any facts that are currently available that could be presented to this panel. And that's why we believe that requiring such a deposit is a breach of the terms of the contract, and why we raise that issue in our complaint.
Okay, understood. So your client believes that those 4 triggers do not apply in this case, and you understand Dominion's argument to be that that section doesn't apply to this case. Is that fair?
Yeah, I would suggest that based on what we've heard today, that they concede that Lauscha doesn't fall within any of those 4 categories, because quite frankly, if we did, I think they would be pointing there, because that would be pretty clear-cut case of we're entitled to a deposit. Instead, they're falling back on this creditworthiness in paragraph 11, which is extremely broad, has almost no limitations other than one request for standard commercial practices. But at the end of the day, it's the only guiding principle I can see in paragraph 11 is it's to provide adequate security for protection against risk of non-payment. Again, there's been no evidence presented before this panel to show that that condition has been met, which even triggers this creditworthiness section to apply as they suggest it should. So again, at this stage of a motion to dismiss, we think that there needs to be a more developed record to see if in fact the demands being made by Dominion are permitted by the contract. We would submit they're not. And we just believe that we should have a hearing on that issue if that's the question that needs to be answered.
Okay, understood. Thank you for that. So we can take those the 4 triggers. We can take those off the table at least for now, because it seems that both your client and Dominion, for different reasons, believe they don't apply here, and we can transition to creditworthiness. Now, is it your client's position that nothing in your client's business practices has triggered the need for a creditworthiness review?
If you're looking at paragraph 11 of the agreement, they've conducted reasonable credit reviews, I believe, throughout the time that they've been providing service to Lauscha. We've provided information to them by the records that I can see that has satisfied them up until most recently. They told us that this internal Dominion credit matrix calculation, which is not referenced in any of the contracts, is the basis for what they're now claiming is why they need this credit review and this surety. And again, as I mentioned earlier, the electric services contract does provide that as one of the 5 categories for a credit check. But what we just looked at in 4D doesn't have it in there. So, you know, again, we didn't draft the contract. If they wanted to use that basis to implement this creditworthiness, they could certainly include that in the category, but they didn't. And we just would ask that they be held to the terms of the agreement they drafted.
Okay, so what I'm trying to do is figure out where we agree and where where there is agreement and where there is not agreement, where there's agreement and where there's disagreement. So does your client agree or disagree that under Section 11, Dominion may conduct a credit review?
The language of the document says that they can. And we provided the financial information that they requested, and it's the same financial information they've requested in the past that we gave it to them. And from my knowledge, there was no problem up until, again, as I mentioned, this other criteria they imposed that was not part of the contract. And then nothing we provided could satisfy them.
Okay. So the company, or your client, your client agrees that the company has the authority under Section 11 to conduct a credit review.
What says a periodic reasonable credit reviews, but yes, I mean, we're not disputing that the language doesn't say exactly what it affords, but it does say that this credit review is designed to provide adequate security for protection against the risk of non-payment.
Understood.
So there needs to be something that anchors this credit review to, you know, that the reason why you're doing it is because you're concerned that you're not going to get paid. I don't think Dominion is they're not out there to be an Experian or an Equifax where they're just be running credit checks, you know, and developing credit records for all their clients. You're supposed to be doing it to verify that there's some sort of belief you're not going to get paid. And we've provided them information for years that up until recently was not a problem for them to, you know, be satisfied that they had adequate security for protection against the risk of non-payment. It was only once this internal credit matrix document criteria was implicated that they changed their position on this creditworthiness position.
Okay. So your client and the company agrees that they may conduct a credit review. And from what I'm hearing, we agree that the credit review was conducted. The results of the review, the most recent review, caused the company to make a request. And it seems that's where the disagreement begins to arise. Is that a fair statement?
Well, the language says that after the credit review, it says the buyer agrees to assist in these reviews and will maintain such credit support to provide adequate security for protection against the risk of non-payment. And I'm paraphrasing a little bit the last sentence. So just because there's got to be something that they can establish that shows they need this credit support to provide for adequate security for protection against the risk of non-payment. Where's the risk of non-payment here? We don't believe that they've met that burden in this particular situation.
Okay. So let me ask you this question. What would create a risk of non-payment, in your opinion?
I think the categories that we looked at in 4D, which is why I think they're in the terms and conditions, are legitimate reasons why a company might have some concern about a risk of non-payment. They're fairly well identified and spelled out.
Great point. Are they the only reasons?
No, I mean, honestly, it doesn't say it. I think it says that a cash deposit shall, and again, I might have to get my glasses out to read this particular section, but let me. I mean, 4D says may be required from a customer as security for payment of the account before services rendered or continued if any of the following conditions exist. It doesn't say including but not limited to these conditions. So in answer to your question, I would submit to the commission that Dominion's contract does appear to limit concerns about creditworthiness in 4D to these 4 categories. They could have easily drafted this to, you know, identify that these are some of the conditions we'll consider, but there are other reasons why we might, but that's not what the language says. So I think that per this contract, maybe not in real life, but per the contract, they've staked themselves out for the 4 conditions. Again, and if you look at, again, the electrical services contract, which we also had, my client did have, it has a 5th category, which opens up a whole other universe of creditworthiness issues that's spelled out pretty clearly in the contract. And it expressly refers to the credit matrix that we've been talking about. So if we were talking about that contract, then you could say, well, yeah, if there was a credit review that showed you fell below some certain standard at Moody's or whatever, Standard & Poor's, that might, it's one of the 5 categories for requiring a deposit. I mean, so clearly Dominion understood how to draft a contract that had that option in it. They just didn't use that option in this particular contract.
Understood. You would agree with me, though, that Section 11 does not limit, exclude, or even identify what could cause there to be concern about credit worthiness or concern about ability to pay, to protect from the risk of non-payment. That is not clearly, or I should say, that is not enumerated in Section 11. It seems to, you could argue, it seems to give broad discretion or some level of discretion to the seller as to what could create conditions for non-payment.
To answer your question, I would agree with that, but I would also make the important note that South Carolina law requires you to read the entire contract as a whole when interpreting a contract. You're not supposed to pick and choose parts that you don't like. And so if you read the contract as a whole, you've got a creditworthiness section that's extremely broad, and then they intend to narrow it down with these terms and conditions that are incorporated. So I would suggest that taking paragraph 11, pulling it out of this large contract, which includes the base contract, the industrial terms and conditions, and then the specific gas terms and conditions, is inappropriate when you're looking at a contract under South Carolina law. You need to look at it all together. When you do that, you see how the contract limits the creditworthiness investigation. So I don't believe it's appropriate to take this in the abstract, paragraph 11. You need to look at it within the context of the entire contract, which is what, you know, again, right below it in paragraph 13, the general terms and conditions of the Industrial Services Commission are incorporated by reference. And then, you know, the other language in the other terms and conditions, you know, indicates that as well. So again, I think you need to read it as a whole, not as just focusing on this paragraph 11.
Understood. My last question for you, and I'll if you want clarification or you have any comments, you're welcome to spend as much time as you need. Was your client offered the opportunity to provide either a letter of credit or a cash deposit? Were there any limitations when surety was requested on what that looked like? It wasn't one and not the other, it was either.
Again,
or
without,
was it not?
you know, again, just trying to be mindful of, you know, what we've really moved far away from the pleadings, but I do want to try to answer your question. And again, I think I tried to answer it earlier in probably not a very artful way, and I apologize. If you go back and look at the history of the interactions between these two parties during this discussion, it's occurred over a good length of time. And depending on where you pick up the chain of discussion between these two parties, you'll see different answers to that particular question. Meaning that I can go back and look at emails that talked about, you know, substantial cash deposits being demanded. There's other spots where now we're talking about sureties, and then there's a different number. So it's been sort of a moving target. I understood counsel here today say that there wasn't a cash deposit that was being demanded. It was some other form of surety. But again, to answer your question, I think you were asking from a more historical nature about what Dominion has asked of my client. And I say that really depends on, you know, what point in time you're asking that question. And I also sort of tried to qualify my answer again as being Lauscha's position is not that if the terms and conditions of the contract required some sort of surety, whatever that might be, and the conditions were met, that's an entirely different situation than what we're dealing with here. We don't believe the terms and conditions have been met to require the surety, which is why we're here arguing about it. And the reason that is because of the company that owns Lauscha is a private equity company whose business model, you know, is such that they don't take on unnecessary debt that they don't have to. So it's not as simple as going, oh, they're good for it. They're, you know, a multinational company with, you know, billions of dollars under their control. It's, are they contractually obligated to do it? And if that's the situation, then that's a different question than what we're being asked here today, because we've looked at the contract and we don't believe that they have met the terms of the contract to make that request. You went on mute.
I'm sorry about that,
That's
sir.
fine. No.
If I'm understanding your answer correctly, whether or not the company demanded cash only or offered the opportunity for a letter of credit is not important at this point.
Right. We don't believe that the contract terms have been met that would allow them to make that either of those requests.
Roger that. All right, sir. Thank you so much. I really appreciate you indulging me. That's all I have, Madam Chair. Thank you.
Commissioners, anything further from Mr. Malone? Mr. Malone, thank you.
Thank you.
Any brief reply? Guess which word is emphasized there?
Thank you. And I heard the commission's directive. I will hit two, I think, critical overarching points. And this goes a little bit to Commissioner Justin Williams back and forth. You just heard counsel conclude that basically their private equity owner isn't going to provide unnecessary debt. Lauscha, the customer in South Carolina, signed a contract that requires them to post credit support security when appropriate. They can't just ignore that because their owner says, we're not in the financial business to do that. Now, and Commissioner Justin Williams, sorry to use your first name, but you're not in the room. There is nothing that necessarily requires a trigger to use paragraph 11 of the contract. Lauscha agreed to allow periodic credit reviews. It happens just over the course of business with every customer, like I mentioned earlier. And also, I think it's important, Lauscha just introduced a position that we've been chugging along, everything's been hunky-dory, and there's been no risk of non-payment for years. I understand we're in a motion to dismiss, but we now get to respond to that, even though the answer might be outside of the complaint, because they introduced it at this hearing. S&P issued a credit rating downgrade of Lauscha to CCC negative with negative outlook. That triggered this whole business. They might have been chugging along in perfect creditworthiness. They're now in junk status, more or less. So I think that's important. And then last point, Lauscha has led with an issue of ambiguity in paragraph 11 of the contract. When these contracts are presented to this commission, the customer gets to participate. They get to raise any objections or challenges to the contract should they wish. This contract's been reviewed, approved, altered, but not the creditworthiness provision since 2009. At no time in any of those proceedings has Lauscha ever argued that the simple, straightforward language in paragraph 11 of this contract was in any way ambiguous. It's not, for the reason that I enunciated earlier, and the commission should dismiss the complaint based on those clear and unambiguous terms.
Anything further? Commissioner Caston?
Madam Chair, thank you. Mr. Anselmo, relative to that paragraph 11, is it a fair assessment to say that that paragraph 11 is intended to provide protection against risk of non-payment?
The security provided by the surety or the credit support provided by the customer is what's intended to protect against the risk of non-payment. That is to protect the other customers. As we discussed earlier, the first step is you have to have the review. Then, if there's an issue that comes up, we say, wait a minute, customer, let's see some numbers. Maybe we can waive this thing. And if it's still in a position where there is risk of non-payment for whatever business reason, commercial reasonable business reasons, like one I just mentioned a second ago, they have to provide menu of options on how to provide the amount. It doesn't have to be dollars. And I think this is kind of a red herring, this argument that's been back and forth about whether it was a cash deposit. The only way you can calculate the amount needed is dollars because it's based on usage and payments on the bills. That doesn't mean it has to be dollars paid to the company. Lots of customers do just say, put it on my bill. That's fine. We'll put the amount on my bill and pay it. But it has to be quantified in some fashion, and because it's quantified on billing, which is dollars, it is a dollar amount. The contract, paragraph 11, gives the menu, which is not the universe. It says including but not limited to the ways that a customer can have that surety that exists in order to protect against non-payment. And by the way, if they have a surety and we trug along and situation changes, guess what? They have earned interest on the deposit amount. They get the deposit back if it's cash, plus interest under the regs. So it's not like there's some sort of harm to the balance sheet of the company or any ownership. They actually have a benefit.
So Dominion interprets that paragraph 11 that to make sure that the payments are done, there will be a surety or there will be a deposit. I mean, that's just a given. Is that a fair statement?
Yeah, there needs to be some sort of financial instrument or, bank letter of credit that says they're good for it that can backstop against the event of non-payment.
So it doesn't have to be cash. It could be.
No, it absolutely does not have to be cash.
Okay. And Dominion did use, I've gotten confused in all this. Did Dominion use a credit matrix to determine this? And I think you said 60 days consecutive.
Not on the gas contract.
I'm sorry?
The matrix is irrelevant for the gas contract. There is a separate electric account in which the matrix, which, by the way, was created at request of the commission in 2009, docket 2009-168E, the commission required us to create a matrix so electric customers would know, by the way, when you get downgraded, when you're going to have to post a deposit. The electric side, maybe there is a matrix being used, maybe there's not. It's irrelevant for the allegations of this complaint, completely irrelevant, because they're only challenging the amount of the deposit under the gas contract as evident from their pleadings.
Taking a little while to get there, but I think I've got it.
There's a lot of moving parts. I'm not going to lie. I mean, long-term customer, multiple gas, electric. I understand. I'm happy to help explain.
Thank you. I have no more questions.
Commissioners? Thank you, Mr. Anselmo. Does ORS have anything?
Nothing from ORS, thank you.
I should have asked before now. I apologize.
No problem.
Gentlemen, thank y'all. Appreciate your appearance today, appreciate your arguments, and we'll take this under advisement and notify you as soon as possible. And with that, you need anything else? I don't think we have time. And with that, we will adjourn this proceeding and wish y'all all a good afternoon. And we are adjourned. Thank you.